Max Lordship.
Yes, please.
Lordship, I may be allowed to mention item number 41, Lordship. Lordship here, come for respondent, number 4. Lordship, if the matter can come up tomorrow, Lordship. It's number 5, my apologies. 41.
On the prayer of Mr. Fuseko, the learned counsel for the respondent number 5. Pass over the case.
Lordship, I also beg to, I also want to beg mention item number 44, Lordship. We also on for this, all the respondents, Lordship. No, all the private respondents.
Yes.
If the matter can come up after 3 weeks, Lordship, my senior is out of station.
Who is your senior?
It's Mr. P.P. Paul. His
Yes,
name is
sir.
not reflected there.
Fuseko, learned counsel for the respondent submits that a 6th adjournment of the case on the ground that Mr. P.P. Paul, the learned counsel for the respondent,
Private respondents here.
for the private respondent, is out of station. Where is allowed? Listed of the
Lordship,
3 weeks,
there's
Lordship.
interim will continue.
The interim order posterior shall continue till the next return of the date.
Thank you, Lordship.
Please, my lord. Lordship, I may be allowed to make a mention for hearing item 45. I have a consensus prayer, Lordship, if it can kindly come up after 3 weeks.
Why 3 weeks?
Lordship, there is a similar matter, Lordship, like this, Lordship, pending before this honorable court, Lordship. In that case, certain directions have been given to the government, and then the reply is awaited from the government, which is why, Lordship, it will be better if this matter is listed after 3 weeks. That is after the
Regarding the constitution of the committee,
yes, Lordship.
we are not allowing adjournment on that ground. in several other cases, we have
Lordship.
refused to actually allow adjournment on that ground. We give you 2 weeks' time
Lordship.
on the prayer of Mr. Santiyanga, the learned counsel for the petitioner, listed after 2 weeks.
Oblige.
May I please, Your Lordship?
Yes,
My lord, I beg to mention hearing item number 28 on behalf of my engine, my lord. Kindly list the matter after 1 week, my lord.
this is part heard.
So, my lord, I'm mentioning on behalf of my engine. Let the matter be come up next week, my lord.
Yes, Mr. Imti. No, Imti Longcha. Let us see the file, 28. Let us see. Part heard matter,
Yes, my lord.
listed again tomorrow. No adjournment. Tomorrow on the basis of materials available on record.
Much obliged.
Yeah, please, my lord.
Yes,
My lord, I beg to mention item number 40, my lord. My lord, this matter, I've been instructed to withdraw the petition, my lord, so kindly allow me to.
you're the counsel for the petitioner,
Yes, my lord.
Mr. L. Likasa Sankam. Learned counsel for the petitioner submits that he has instructions to withdraw the writ petition. The writ petition is accordingly closed as withdrawn. Okay,
Our pleasure.
May I please, Your Lordship?
yes,
Your Lordship, I beg to mention item number 33 and 34. Your Lordship, I've recently received this file from Livika, so kindly grant me 3 weeks' time to go through this.
33, 34.
Yes, Your Lordship.
MS, AIME. 6 adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly. Okay,
Your Lordship, similar prayer for item number 35 also.
okay,
Kindly let it come up after 3 weeks.
35, same order, after 2 weeks.
Your Lordship, and item number 36, 37, and 38 also.
Same,
Yes, Your Lordship.
same order after 2 weeks.
Yes, Your Lordship. Lordship, I beg to mention item 29, 30, and 31, Your Lordship. Your Lordship, I've been recently handled this file, Your Lordship. Your Lordship, may kindly grant 3 weeks' time, Your Lordship,
Item 29, 30.
and 31, Your Lordship.
MS Inaholi, the learned government advocate is granted adjournment for 3 weeks. Okay,
Much obliged, Your Lordship.
Your Lordship, I beg to mention item 43 on behalf of Sipong Chang, Government Advocate.
Yes,
And with the consent of the petitioner, we pray for 3 weeks' time, Your Lordship, as she's in this post.
Mr. So-and-so. Learned counsel makes a mention on behalf of Mr. M.S.S. Chang, the learned government advocate, and seeks adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly. Okay.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention hearing item number 42, Lordship. Lordship, this matter has been recently endorsed in the Lordship. If this matter can come up.
Mr. V. Jimoni, the learned government advocate, seeks adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly.
Mr. Lordship,
Yes.
I'd like to mention item number 32 on behalf of City General. Let the matter come up after 2 weeks.
Okay. 32,
Yes, Lordship.
Mr. So-and-so, learned counsel makes a mention on behalf of Mr. City Jamil, learned senior counsel for the petitioner, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Okay.
For motion, item number 1.
Yes,
Please, Your Lordship.
yes.
Lordship, in this petition, the petitioner is aggrieved
Yes.
because of the certain issues regarding his promotion, Your Lordship. He was found to be eligible, Lordship, to be promoted in the post of principal. Lordship, unlike other department, the Department of Higher Education follows a different procedure, Lordship. And as per the service rule, Lordship, though they are, the petitioner has been appointed as a lecturer initially, Lordship. Then he was promoted, which is the nomenclature is changed as assistant professor now. Then he has been promoted as an associate professor and has been serving the department of under the higher education, currently posted in Kohima Science College, Lordship. Now, in the year 2000, last year, Lordship, on 24th, on 24th May 2023, an advertisement was issued by the department, Lordship, calling for eligible candidates to be considered for promotion to the post of principal, Lordship. Now, in that advertisement, there's certain criteria that has to be fulfilled. One is, Lordship, the advertisement is in page number 41. One is person should be associate professor with PhD who have completed 3 years of service in stage 4, minimum yearly / community API academic performance indicator scores using the PBS scoring performance per the norms, a minimum of 5 publications since the period of the teacher's place in stage 3. Appointment shall be as per existing Nagaland Higher Education Service Rules 2015, Lordship. So this is not a new recruitment, it's just a promotion, Lordship, under the career advancement scheme, Lordship. Then in page number 42, Lordship, I have enclosed a notification dated 5th August 2023, Lordship, wherein it says that 10 candidates have been screened by the screening committee and found to be eligible for the post, Lordship. And so they were called for interview on 17 August 2023, Lordship. Then accordingly, the department has constituted an expert committee comprising of 6 members, Lordship, in the expert committee. Now, the interview assessment sheet is in page number 44. This is the result, Lordship. Page number 44. This is the result. And then accordingly, based on merit cum seniority list, the expert committee has assessed them. And then this is the select list, Lordship. So in this list, petitioner was placed in merit cum seniority list number 5, Lordship. Now what has happened, Lordship? This expert committee has clearly stated in the result saying that this certified that the candidates recommended and selected will be valid for 1 year. The Lordship, if we look at the service rule of the higher education, it says that there are certain criteria that has to be fulfilled, and then and then those criteria has to be placed before the committee, Lordship, and that has to be valid for a year, Lordship, and then accordingly during that year. Now, from
What
what
is the validity period prescribed by the service rules?
service
Is it
rules?
6 months or 1 year
No, Lordship, it just said a year, Lordship, during the year, Lordship.
during a year?
Yes, so 6 months validity was never prescribed, Lordship. But if we see the interview result, Lordship, this is the expert committee's recommendation that it has to be valid for 1 year, which is also not denied by the department. Now, Lordship, so the result was declared came into effect from 17 August 2023. So it is valid till 17 August
So
2024.
basically your promotion was denied on the ground that the validity period is only for 6 years, 6 months.
Yes, initially they admitted that it's for 1 year, Lordship, as expert
But
committee.
the denial of your promotion was on the ground that the result was valid only for 6 months.
No, Lordship, that is what we are contesting in this petition, Lordship, because the
That is the ground taken by the state respondents to deny your promotion.
yes, Lordship.
Ah.
No, I'm agree with that because nowhere in the service rule it says that it has to be 6 months. Lordship, if that is at all, we have to consider, Lordship, we have to consider the expert committee's recommendation because the service rule has, given the authority to the committee. So accordingly, the committee has recommended it has to be valid for 6 months. Now, Lordship, because here I would
It
say
has to
that.
be valid for 6 months.
Oh,
1 year.
sorry, 1 year, Lordship. It has to be valid for 1 year, which is also not denied, Lordship. If you see the
So I just precisely, I just want to understand your case.
Lordship,
The ground why promotion was denied to you was because they say that the validity period of the result is only for 6 months.
this is what the director is saying, Lordship.
That is what.
Yes,
That it
yes.
is on that ground that you were denied promotion.
Yes, Lordship, yes. Now, Lordship, if you look at page number 46, Lordship, here the director himself has written to the commissioner and secretary. Letter dated 29 April 2024. Kindly allow me to read it, Lordship. Submitting a proposal for appointment of principal against 2 anticipated retirement vacancies in May and June 2024 respectively. With reference to the subject cited above, I am to submit here with a proposal for appointment of principal against 2 anticipated retirement vacancies in May and June 2024 under Ziniboto Government College, Ziniboto, and Wangkau Government College, Mon. In this regard, I am to submit as follows. Principal Ziniboto Government College and Principal Wangkau Government College are due to retire with effect from 31st 05/2024 and 30/05/2024 respectively. Against the anticipated retirement vacancies, proposal to fill up the vacancies ahead of time to ensure that colleges are not left without principal is submitted under Annexure 2. The recommendation of the last interview board held on 17 August 2023 is valid for 1 year. As per the
Which is the letter or the order which says that actually validity period is only for 6 months?
Yes, I will go to that, Lordship.
Which is
Here, yes, in page number 50, Lordship.
50.
Yes,
Let us see page 50.
page 50. Lordship, it says the submitting a proposal for appointment of principal and requesting for administrative approval for advertising and conduct of screening for appointment of principals. With reference to the subject cited above, I am to submit here with a proposal for appointment of principal and request for administrative approval for advertising and conduct of screening eligible candidates to the post of principal. In this regard, I am to submit as follows. Advertisement to the post
No,
of.
madam,
Yes, Lordship.
I am actually like asking you, where is that order or the circular which says that the validity period of the result is only for 6 months?
Okay, Lordship, it's in page number 51.
Ah,
Lordship.
51.
Yes. This is notified to all concerned that the interview recommendation to the post of principal held on 17/08/2023 is no longer valid as the period of 6 months is over. The validity of 1 year recommended by the committee is not accepted by the government. Therefore, candidates in the wait list are advised to submit fresh application to the post of the principal. Lordship, this is the circular that I'm also challenging through this petition, Lordship.
Third, MS. Nichokoza, the learned counsel for the petitioner. The petitioner is currently serving as the associate professor under the Department of Higher Education at Kohima Science College, Zotsuma. Stop. On 24/5/2023, respondent number 4 issued advertisement for the post of principal. From eligible candidates in the government colleges in the academic level 14 within brigade rupees 1,44,200 and special allowance of rupees 2,000 per month. The essential qualification required for the post was prescribed in the advertisement. Stop. Stop. By the notification dated 5/8/2023. Respondent number 4 no. On 5/8/2023, a notification was issued by the respondent number 4 stating that the screening committee as per the Higher Education Service Rules 2015 found the academic performance indicators within bracket API of 10 candidates to be eligible for the post of principal and accordingly recommended their names and directed the candidates to appear for interview with the requisite documents on 17 August 2023. Stop. In the said list, the name of the petitioner appears at serial number 5. Stop. The petitioner accordingly appeared the interview on 17/8/2023. And after the expert committee has assessed all the candidates, released the assessment sheet on the same day. And in that, the petitioner was placed in serial number 5 of the list. Stop. The result was certified to be valid for a period of 1 year by the expert committee. Thereafter, three of the successful candidates in serial number 1 to 3 of the exam held on 17/8/2023.
Yes, Lordship. That is interview.
Were given officiating promotion as principal to the three colleges, namely Futsal Government College, Futsal, Zizazi Presidency College, Ipiri, and Chang College, Doingsa, by the notification dated 2010-2023. That thereafter, by the letter dated 29/4/2024, the respondent number 4 wrote to the respondent number 2, proposing the name of the petitioner along with one Dr. Achumi Ism to be appointed as the principal against two anticipated vacancy arising during the month of May and June 2024 at Zindaboto Government College and Wangkau Government College, Mon. The case of the petitioner for promotion to the post of principal was, however, not considered on the ground that the validity period of the result held on 17, correct?
Yes, Lordship. 17/8/2023.
Held on 17/8/2023 is valid only for a period, of 6 months and not 1 year. In the present petition, the petitioner has impugned the letter dated 3/6/2024, written by the director to the additional secretary to the government of Nagaland, higher and technical education, submitting proposal for appointment of principal and requesting for administrative approval for advertising and conduct of screening and for advertisement and for conduct of screening of the eligible candidates to the post of the principal. The circular dated 4/6/2024 issued by the respondent number 5 stating that the interview recommendation to the post of principal held on 17/8/2023 is no longer valid as the period of 6 months is over. And the validity of 1 year recommended by the committee has not been accepted by the government. The advertisement dated 4 June 2024 issued by the director, issued by the respondent number 4, advertising the post of principal and inviting applications from eligible candidates in government colleges for appointment to the post of principal, and the notification dated 19/6/2024 issued by the respondent number 4, conveying that the candidates whose API were found eligible to the post of principal are hereby informed that oral interview shall be held on this date has lapsed 24/6/2024 in the conference hall of the Directorate of Higher Education, Nagaland, from 10 hours onwards. Madam, this date has lapsed. 24
Lordship, yes.
Then,
Lordship, I was also, that's why I was reasoning with the department to consider the committee's, expert committee's recommendation, Lordship. I have also sent a letter of
has the
complaint.
interview been held?
Lordship, yes.
Interview
Result,
been,
interview is held, result is to be released, Lordship.
interview is not held.
Interview is held.
Interview is held on 24 June 2024.
Lordship, yes. Result is yet to be released, Lordship. That's why I have to impugn the.
Issue notice to the respondents, returnable after 4 weeks. Mr. Kiangami, oh, sorry, the Learned Senior Government Advocate accepts notice on behalf of the state respondents.
1, 2, 3, and 4, my lord.
Number 1, 2, 3, and 4. Therefore, no formal notice need be issued to the state respondents. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned senior government advocate
Lordship.
in the course of the day.
Yes, Lordship. I have extra copies.
In the course of the day.
Lordship, I have an interim prayer, Lordship.
Lordship, as far as the interim is concerned, now the petitioner has complied to the advertisement. Had he not complied to the advertisement and appeared before the interview.
You have
he would-
also appeared.
Yes, because he's,
Subsequent advertisement.
yes,
Lordship, I have to clarify from a petitioner, Lordship.
interim may not be considered
No,
today, my lord.
no, as per a notification, your name also appears at
Serial number
serial
5,
number 5.
my lord.
As per the notification dated 19/6/2024.
Correct, my lord.
Lordship, kindly allow me to clarify that. In the meantime, Lordship, since if the interim relief is not granted, Lordship, the purpose of this petition will be
Lordship,
futile, Lordship.
if the result is declared, and if any other candidates has been selected from among these 9 candidates that were asked to appear at the oral interview, then in that case, your lordship, those candidates who has been selected has to be implemented, your lordship, without hearing them.
Lordship, if that is necessary, I shall take steps, Lordship.
So
But-
as of today, your
but the
lordship,
result is
interim may be
that-
kept open.
It will not affect any other person's, Lordship. Even if interim relief is granted, result is awaited and then
Okay, let us examine the matter.
Lordship.
In the interim, on considering the submissions made by the learned counsel for the petitioner and the materials available on record, this court directs the respondent number, two and four.
Yes, your lordship, it should be 2 and 4, madam.
The respondent number 2 and 4. Not to declare the results of the oral interview held on 24/6/2024 till further orders of this court.
If it is not declared, your lordship, as of today.
Okay. Till further orders of this court. Comma, if the result has not been declared as of today. Okay.
oblige, Lordship.
Obliged, my lord.
For motion item number 2,
Yes, Likha, say what is your case?
Please, my lord, My case is that the petitioner was appointed as work judge, bill assistant under the establishment of executive engineer doing some division, my lord. And I was posted at Kifri, my lord. And my lord, while I was serving uh, at- under the same department by an impugned order dated B my annexed B, my lord, page 17. There is there are issued by the engineer in chief, my lord, married, my lord. Government of Nagaland, Department of Power, Office of the Chief Engineer in Chief, Nagaland, Kohima, Office Order Number 200, so and so, in the interest of work, Srimati Yotingla Sangdam, work judge, bill assistant under the establishment of Executive Engineer, Electrical Division, Kifi is hereby transferred to Executive Engineer, Electrical Division, Mon with immediate effect, my lord. This is the order, impugned order, where I've been transferred from the executive engineer, Kifri, my lord. However, this order was never issued to me, nor to the respondent number 4, my lord. And even if this order was passed by the office, by the respondent number 3, I was serving and performing my duty under Kifri division, that is under the establishment of respondent number 4 for my lord. And my lord, all this while I was serving there, and thereafter another impugned order was issued to the petitioner, my lord. That is Annexure C, page number 19, my lord, and type copies at page number 20, my lord. Married, my lord. Annexure C, my lord, page 20. Government of Nagaland, Department of Power, Office of the Engineer-in-Chief, Nagaland, Kohima, Office Order Number so and so. The service of the following persons are hereby terminated with effect from 2010-2023, my lord. So this is the impugned order where I was terminated from service along with 6 others, my lord. And my lord, this order was also not communicated to me nor to the respondent number 4. And my lord, I was allowed to work under the establishment of the respondent number 4, even after this impugned order was issued. And my lord, sometime in the last part of May 2024, when I visit the office of the respondent number 2 for some official work, there I was informed that I was issued with the impugned order dated 2012, 2017, and also with the order 2010, 2024, my lord. Only when I visit the office of the respondent number 3, I was given with the 2 impugned order, my lord. And thereafter, I've wrote a letter to the representation to the respondent number 3. That is at page.
Mr. Lekhase,
Yes, my lord.
you always bring a peculiar case, oh?
Yes, my lord. My lord, Annexure D, where I wrote a representation to the respondent number 3 to reinstate the petitioner in service, my lord.
Annexure D,
Yes, my lord.
which is the page?
Page number 21, my lord. Page number 21, my lord. Married, my lord. And my lord, this is the representation I submitted to the respondent number 3 through the respondent number 4. my lord, and Annexure C is the letter which the respondent number 4 has forwarded along with my representation to the respondent number 3, my lord. May I read, my lord? Annexure E, page 22, my lord.
Mr. L. Likase, the learned counsel for the petitioner. The petitioner was appointed as work charge bail assistant under the establishment of the executive engineer within bracket E division doing some and posted at Kipri. It is the case of the petitioner that while he or she,
My lord.
while she was serving under the establishment of the executive engineer E division doing some, the respondent number 4.
No, my lord. Now, EE Twengsang and Kifu has been
Are
separated,
you
my lord.
understanding what I'm dictating?
Yes, my apology. Yes, ma'am. Yes.
She was first appointed under the establishment of executive engineer E division doing some.
Yes, ma'am.
Huh?
Yes,
That is
yes.
what I'm saying. What was that? Pardon? Under the establishment of the respondent number 4. At posted at Kipri. Where are you? Please read the whole thing. Under the respondent number 4. By the office order dated 2012-2017. The petitioner was transferred to the executive engineer within bracket ELECT electrical with a close bracket division MON with transferred to the executive engineer electrical division MON.
My lord, I made a party as respondent number 5, my lord.
That is the respondent number 5. It is further the case of the petitioner that the transfer order dated 2012-2017 was never intimated to the petitioner. And despite the order dated 2012-2017, the petitioner was regularly attending to her duty and drawing her monthly salary from the establishment of the respondent number 4 for nearly 6 years. Stop. It is only when the petitioner visited the establishment of the respondent number 3, sometime in the last part of April 2024, she was served with the transfer order dated 2012-2017 and the impugn order dated 27/10/2023. By which the service of the petitioner had been terminated with effect from, which has been terminated with effect from 2010-2023. was served with the impugn order dated, last one? 27/10/2023, correct? By which the service of the petitioner was terminated from, with effect from 20/10/2023. The petitioner thereafter had submitted the representation dated 2/5/2024 to the Engineer-in-Chief, Power Department, Kohima, Nagaland, for review of a termination order. But the representation does not evoke any positive response. Being aggrieved, the petitioner is before this court. Issue notice to the respondents, returnable after 4 weeks.
My lord,
Your lordship.
my lord, I have an interim prayer, my lord.
No interim, you're out of service.
My lord, after the termination order was issued, I was attending to the office
Mr.
till
What was the last line?
till 25th of May
What
2024,
was the
my lord.
last line? Last line? 4 weeks. Mr. N. Angami accepts notice on behalf of the respondent number 1 to 5, therefore no formal notice not be issued. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned senior government advocate within
A day, my lord.
a period of,
A day, my lord. Within the course of the day, my lord.
in the course of the day. Okay.
My lord, kindly consider the prayer,
You
my
are out
lord.
of service.
Obliged.
My lord, but I was drawing my salary till March 2024, my lord.
It doesn't improve your case. Yes,
For motion item number
Okay.
3,
Please, your lordship.
yes, please.
The counsel leading this matter is from Delhi and he could not arrive today. So kindly this matter may be adjourned and then maybe posted on Friday, that is 9th of August.
Friday.
Yes, your lordship.
Mr. Ayamchan. The learned counsel submits that. Mr. Who is the leading counsel?
Ketan Jain, your lordship.
Mr. So-and-so. The leading counsel for the petitioner has some difficulties today and therefore seeks adjournment of the case on
9th August, your lordship.
Why can't we have it on 12th?
Yes, your lordship.
On 12th, 8/2024. Prayer is allowed. Listed report.
Much obliged.
for admission item number 4,
May I please, your lordship?
Yes.
I received the additional affidavit by the government today. So 2 weeks. time may be-
Additional affidavit.
Yes, your lordship. So 2 weeks time may be granted to go through the affidavit and make necessary reply.
MS
Tushi Jimmy.
so-and-so, learned counsel for the petitioner submits that she may be allowed 2 weeks' time,
3 weeks, your lordship.
3 weeks' time to file rejoinder affidavit to the additional affidavit filed by the state respondents. Prayer is allowed, listed according.
for admission item number 5 and 6.
Yeah, Billy's your lordship.
Yes.
Your lordship, in compliance to the direction of the honorable court, this to analogous matter happened, reassigned to Subala Chang. But unfortunately, he is indisposed today. And regarding the item number 6, I think it's pertain to the withholding of the salary. I learned from the department that there is
Why 5 and 6 are clubbed together? Is it, why 5 and 6 are
I
clubbed
have a
together?
similar prayer, this 5 and 6.
What is your prayer, ma'am?
Your Lordship, here I'm praying for minimum scale of pay as well as for release of your salary.
Release of salary.
Your Lordship.
You have not been paid your salary.
Yes, Your Lordship.
Since when?
Here in item number 5, my salary, I have not received my salary with effective from March 2022, Your Lordship.
March?
2022,
Are you still in service?
Your Lordship.
Mr. Im Tim Sung, the learned additional advocate general, submits that MS S. Chang, the learned government advocate, to whom the case has been entrusted, has some personal difficulties today, and therefore seeks adjournment of the case after a week.
2 weeks,
Why? After
after 2 weeks.
2 weeks. Prayer is allowed, listed after 2 weeks. It is however made clear that pendency of this writ petition shall not be about to the state respondents to release the error/pending salary of the petitioner. Okay.
That's right.
For admission, item number 7.
May I please, Your Lordship?
Yes, ma'am.
I'm appearing on behalf of my senior, Mr. Subungwati.
Okay.
Your Lordship, we have received affidavit in opposition and also additional affidavit. So I pray I may be granted 3 weeks to file affidavit in reply.
MS Senso, the learned counsel for the petitioner is allowed 3 weeks time to file affidavit in reply.
For admission, item number 8.
Your Lordship,
Yes.
I pray I may be granted 3 weeks to file affidavit in reply.
MS Senso, the learned counsel for the petitioner is allowed 3 weeks time to file affidavit in reply.
For admission, item number 9.
Yes, Mr. Fuseko.
Lordship, the security government is here to file affidavit, Lordship.
That is a lordship. Lordship, I am for respondent number 1, 2, and 3, Lordship.
1, 2, and 3.
Lordship. I'm here to file my affidavit in opposition, Lordship, since certain clarification has to be sought to the department. Lordship. So if Lordship may please grant 3 weeks time.
Who's for 4? Have you filed your affidavit, ma'am? Mr. V. Jamomi, the learned government advocate, is allowed 3 weeks time to file affidavit in opposition.
Right.
For admission, item number 10.
May I please, Lordship?
Yes.
Lordship, this matter is a fixed item,
Ah,
but I have a prayer, Lordship. My senior city is in disposal, so kindly adjourn this matter for some time, Lordship.
It's for admission hearing, madam.
ah.
It's for admission.
You should have at least informed him.
In fact, Lordship. So,
He's out of station.
Lordship is in disposal.
Okay. So when do you want it?
Lordship, 3rd of September
3rd of September.
as a fix.
Lordship, for admission hearing. Yeah.
What is so auspicious on 10th? You're the counsel for the
Lordship, I'm for the private response.
private. I am Chin.
Lordship, I am Ali Wazukum. I am Chin was the previous person who appeared in the motions.
Mr. Aliba Ozakam. The learned counsel submits that Mr. City Jamil, the learned senior counsel is indisposed and therefore seeks adjournment of the case on 3/9/2024. Where is allowed? Listed on 3/9/2024
For admission hearing, my lord.
for admission. hearing.
Lordship, the interim may be continued till.
So the interim order passed earlier shall continue till the next waiting.
Obliged, Lordship.
Permission item number 11.
May I please, Lordship?
Yes.
Lordship, kindly grant me 1 week time, Lordship, to file my affidavit
Affidavit.
in opposition.
Oh, you are for the private
Respondent
respondents?
For Lordship. Taken the consent of the petitioner.
Who is the petitioner? Who is the petitioner?
Mr. M. Makam.
Then Makam.
Yes, I've taken his consent.
He is not here.
No, Lordship, he's not here today.
None appeared for the petitioner. Mr. Fuseko, the learned counsel, for the respondent number 4, is allowed 3 weeks time to file affidavit in opposition. Listed report.
Permission item number 12.
Yeah, please, Your Lordship.
Yes.
Here the state is yet to file counter, Lordship. Here the
Mr. Vijimomi, the learned government advocate, is allowed 3 weeks time to file affidavit in opposition.
Permission item number 13.
Your Lordship, kindly
Yeah.
grant me 3 weeks time to file affidavit. State is said to file affidavit. Your Lordship.
MSDI, the learned government advocate, is allowed 3 weeks time to file affidavit in opposition.
Item number 14 and 15.
May I please, Your
Yes,
Lordship?
MS.
Lordship, may I kindly grant me a week's time to file my affidavit, Your Lordship? On the last occasion, I have been directed to
You have
6.
filed your affidavit, huh?
Lordship, additional affidavit, query, Your Lordship.
What is the, as per the last order?
Yes, Your Lordship.
What was the last order?
Last order dated
6/6.
6, yes, Your Lordship, 6/6, Your Lordship. So to place on record, Your Lordship, the instruction which I've received, a week's time may be granted.
MSS Mary. 6 for 2 weeks time. To place the instructions as ordered by this court on 6/6/2024. Listed accordingly.
I'm obliged.
Item number 16.
Yes, ma'am.
Yes, Lordship. Here, respond number 2 and 3, they have already filed their counter, Lordship.
Just,
And then-
who is 2 and 3?
Lordship, I'm for respond number 2 and 3.
You are for respondent, let me just take the respondent. The respondent number
2 and 3, Lordship.
2 and 3.
Yes, Lordship.
What about, oh, respondent number 2 and 3?
Yes, Lordship.
What about the government and the village council?
Your Lordship, I am for the respondent number 1.
Ah. Will it be necessary for you to file affidavit?
Worship, I'm going to the petition and annexure. Annexure G, which is a judgment pronounced by your worship here, is an interpretation and application of the rule. It is clearly explained in that judgment, annexure G of the petition. So
Annexure G.
Yes.
Let us
So I
just,
think that,
annexure, just wait, Mr.
Page
MP.
number 50.
Annexure G.
Page 50.
Annexure G, G. So you will not be filing your affidavit.
Worship.
Yes, Lordship.
And what about 4?
Lordship, no one has appeared for
Has
the village
notice been
council
served,
yet.
ma'am?
Yes, Lordship.
Has notice been
Lordship,
served? Let
order
us-
dated 4/3/24, Lordship,
4/3,
24.
just wait,
Lordship, we were,
just. 4/3,
4/3/24, Lordship. Lordship, we were allowed to take dusty service,
4/3.
4/3/24, Lordship.
Yes, it's 4/3.
Lordship. And to that effect, Lordship, I have filed my dusty affidavit on 26/3/24.
Where's your affidavit, ma'am?
Lordship, I have filed on 26/3/24, Lordship.
26.
26/3/24, Lordship.
Whether any order has been passed, that notice upon respondent.
Yes, Lordship, 15/4/24, Lordship,
15/4/24.
24, Lordship.
Yes,
Yes, Lordship.
yes. So what is to be done?
So Lordship, if the state is not filing affidavit, Lordship, we can list the matter for admission hearing next week, Lordship, if the Lordship allows.
You have filed your affidavit to entry.
Yes, madam.
So next week, okay, Mr. MT. Mr. Im Song. The learned additional AG submits that the state will not be filing the affidavit in opposition in the case. Stop. Respondent number 2 and 3 has filed the affidavit in opposition. Stop. None appears for the respondent number 4, despite service of notice. On the prayer made by the learned counsel for the parties, listed for admission hearing on.
Lordship, can it be fixed on Monday, my lord?
May I please?
Yes.
Lordship, how about Be fixed on 20, Lordship.
20.
Yes, my lord. Because
20.
there may
Yes,
be some
Mr.
difficulty.
Your Lordship, 1920 I'm out of station.
20, what is the difficulty for you?
Lordship,
Why Mondays?
yes, next week, Lordship, Monday.
There's a fixed matter before the principal seat and my senior is in disposal. So maybe the matter might get adjourned and we are planning to get it fixed on 12 or 13, Lordship. Regarding the PISU motor.
In that case, Your Lordship, let it come up in the first week of September. This month I have some problem.
Okay.
Anytime first week of September.
Second,
That's fine.
2nd September, Mr. Yajimoglu,
That's fine.
on the prayer of the Limit Council for the parties listed on 2/9/2024 as a fixed admission hearing. Item.
Very well. Much obliged.
Much obliged, Lord.
Item number 17. May I please, my lord?
Yes.
My lord, here the affidavit is under preparation, Lordship. So if Lordship may please grant under the truth.
Mr. V. Jamomi, the learned government advocate, submits that the affidavit on behalf of the state respondents is under preparation and therefore seeks what?
Lordship.
2 weeks time.
2 weeks time.
3 weeks time to file the affidavit. Prayer is allowed. Listed.
Obliged.
Item number 18.
May I please, Your Lordship?
Yes, ma'am.
We have received the counter file by the state respondent, so I wait 3 weeks be granted to file affidavit
On
in
the
the
prayer
plan.
of MS so-and-so, learned counsel for the petitioner, listed after 3 weeks for enabling the learned counsel for the petitioner to file affidavit in reply.
Lordship, Lordship, Lordship.
Item number 19 and 20.
May I please, Your Lordship?
Yes.
Lordship, kindly grant 3 weeks time to file my affidavit.
MS Pichano, the learned government advocate, seeks for 3 weeks time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed. Listed report.
Item number 21.
Yeah, please, Your Lordship.
Yes.
I'm appearing for respondent number 4, Lordship.
4.
Lordship. I may be given 3 weeks time, Lordship, to file my affidavit, Lordship.
What about the state? Have you filed finish?
Not yet, Your Lordship.
The Mr. So-and-so, the learned government advocate, as well as MS Akila, the learned counsel for the
Respondent number 4. Lordship.
respondent number 4, are allowed 3 weeks time to file their respective affidavit in opposition.
Obliged, Lordship.
Item number 22.
'22 and '23 are actually analogous, my lord.
Yes.
And I have filed my application for vacation on the interim order. I sent copy on the 4th, it was moved on the 5th. It is finally listed today, Your Lordship.
Yeah.
So by operation of law 226(3), the interim order stands vacated, my lord. Can I place the judgment before Your Lordship? The 2003 1 GLT 346, my lord, a division bench judgment at paragraph 4. May I read, my lord?
Yes.
Under Article 226(3) of the Constitution, any party against whom an interim order, whether by way of injunction or stay or in any other manner, is made, without furnishing to such party copies of such petition and all documents in support of the plea for such interim order, and giving such party an opportunity of being heard, can move an application to the High Court for vacation of such order. When such an application is moved, a copy of the same has to be served on the party who has obtained the order of stay or injunction, or on the counsel of such party, and that the matter has to be heard within a period of 2 weeks from the date on which it is received, or from the date on which the copy of such application is so furnished, whichever is earlier. When the steps are taken by moving an application under Article 226(3) of the Constitution for vacating the stay order, if the application is not disposed of within 2 weeks, it is the mandate of law that the interim order so passed shall stand vacated automatically. The effect of vacation would be as if there is no order of stay in existence passed by the court after the expiry of 2 weeks.
Yes. So what is the facts? Mr. Jimmy, facts.
So, Your Lordship, a bungalow with a compound, government quarter age 44, was allocated to the High Court for the residents, for the judge's accommodation, my lord. Now, what happened was that within this compound, it appears that there was some allotment made to a private citizen, which is the petitioner. So steps were taken. So against those steps, writ petitions were filed. The first writ petition was disposed of, directing the petitioner to approach the commissioner in terms of the Eviction Act, the appeal. That, according to the records which have been furnished, that is pending. That is pending. Now,
Pending before the commissioner?
before the commissioner. This is pending before the commissioner. That is pending before the commissioner. So we were not a party when the petition was moved. We filed an IA, and on the basis of our application, we are allowed to be implemented as the respondent number 6. After implement, I have filed this application for vacation of the stay. So what has happened, Your Lordship, is when the quarter was allotted to us, government quarter AH 44 in New Ministers Hill. Now, when the registry took over possession of this quarter, we found that on one side, it is a wall compound, Your Lordship. On one side, the wall was broken. It had fallen down. But there was no encroachment as such. Later on, we found that on the side where the wall had been broken down or fallen down, as the case may be, some CGI walls had been set up, had been put up. We filed a complaint. We submitted a complaint to the district administration, which resulted in the subsequent process under the Eviction Act. So that is a different process. That is a different process. Now, after the eviction process was initiated, the commissioner again has issued orders on the revenue side. On the revenue side, order has been issued, and the commissioner has approved for the cancellation of the allotment given to the petitioner. On the basis of the approval given by the commissioner, the pata has been cancelled. The pata has been cancelled. So actually, insofar as the writ petition is concerned, Your Lordship, even there, nothing may survive. Nothing may survive. But for us, but for the High Court, Your Lordship will appreciate the residence of judges has to be a secure compound. It has to be a secure compound. And it is a quarter which has been allotted to the High Court. And the approval of the commissioner specifically records that the allotment to the petitioner was wrongly made. It is government quarter, it is land within a government quarter, and the allotment was wrongly made to the petitioner. That order of the commissioner has not been challenged in the writ petition. Only the subsequent order issued by the deputy commissioner, which is based on the order of the commissioner. Now, there are two parts, Your Lordship. There are two parts. Firstly, it is the power rests with the commissioner. The power rests with the commissioner to review all allotments made. Once an order is passed by the commissioner or an approval is made by the commissioner, then only it gets transferred to the deputy commissioner. And the deputy commissioner passes orders on the basis of the commissioner's approval or order, as the case may be. So in the writ petition, what has been challenged is the order of the deputy commissioner. But the order of the commissioner, which is an order again issued under the rules, the land revenue regulations, that has not been challenged. And that
Mr. Ejimomi, land revenue regulation or eviction of person?
Two processes, Your Lordship. There are two processes here. One is the commissioner acting on the revenue side, and one is under the Eviction Act. Two processes. Two different processes altogether. So the action on the Eviction Act is still pending. That's a different issue. But that will also now be affected because of the orders passed on the revenue side. So therefore, according to the state respondents, government land was wrongly allotted to the petitioner. That has been cancelled.
Cancelled by Deputy Commissioner.
With the approval of the commissioner. Under the rules, the commissioner confirms or cancels. Under the land revenue regulations and the rules framed thereunder, it is the commissioner who approves, confirms, or cancels allotment orders in respect of government land. So the commissioner has come to the conclusion that land within the government quarter AH 44 is government land, and it should not have been allotted to the petitioner. That allotment has been cancelled. But that is on the merits, my lord. That is on the merits. Insofar as the interim order is concerned, after I filed the application for vacation of the stay, I filed it, let us say, on the 5th of July, Your Lordship. Today is the 5th of August. 2 weeks is well gone, Your Lordship. So by the mandate of law 226(3), the interim order stands automatically vacated. That is my case here today, Your Lordship.
When did you file this petition?
I filed it on the 4th, it was moved on the 5th. After service of copy. On the 9th. No?
This petition was filed on 8 July.
Filed on 5th?
8.
Yes. Dates are wrong in my entries. 8. 8. It will be 8. Wrong dates.
So if it is 8, whether 226(3) still applies? If it is 8.
14 days, Your Lordship. 14 days. It was moved on the 9th. Your Lordship, may kindly see the first copy, the receipt of the petitioner. Because I think we filed on the 5th. And it came up on Monday. On the flip side of the first page.
5th.
Yes, ma'am.
So the matter petition application has to be heard within 14 days effective from 5/7/2020.
Yes, ma'am. But we were on vacation, Your Lordship, for a short period, and the court reopened on. Till 21, we were on vacation, and the court reopened on 22nd. 22nd. So it should have been heard by the 22nd, no later. Should have been heard by 22nd.
Excuse me for 2 minutes.
Your Lordship,
Yes, yes.
just so that the matter is clear, can we go to, if a copy of the Constitution is available, to 26(3), ma'am? Constitution of India?
When was the last order passed by this court? 9/7.
9/7.
2 weeks. When did you file your objection, ma'am?
On 22/7/2024, Your Lordship. The last, Your Lordship, last listed date again was for admission on 1/8/2024. However,
This.
this honorable court did not say for admission.
1/8.
2024, Your Lordship.
That was?
For admission, it was also listed on 1/8/2024. but
The main
however-
writ petition? Main writ petition?
No, Your Lordship, this IA, Your Lordship. This IA.
1/8.
2024. But however, Your Lordship.
Just wait, I'm not getting that 1/8/2024 order.
This honorable court must say on Your Lordship, availing leave, Your Lordship.
1/8/2024.
Yes, Your Lordship.
That order is not here.
Your Lordship, Your Lordship was not sitting on that date.
Yes, Lordship was on leave, Your Lordship.
Okay, okay. So at least some concession. Okay, okay.
226, clause 3, my lord. May I read, my lord?
Yes.
Where any party against whom an interim order, whether by way of injunction or stay, or in any other manner, is made on or in any proceeding relating to a petition under clause 1, without A, furnishing up to such party copies of such petition and all documents in support of the plea for such interim order, and B, giving such party an opportunity of being heard, makes an application to the High Court for the vacation of such order and furnishes a copy of such application to the party in whose favor such order has been made, or to the counsel of such party, the High Court shall dispose of the application within a period of 2 weeks from the date on which it is received, or from the date on which the copy of such application is so furnished, whichever is later, or where the High Court is closed on the last day of that period, before the expiry of the next day afterwards on which the court is open. If the application is not so disposed of, the interim order shall, on the expiry of that period, or as the case may be, the expiry of the said next day, stand vacated. So it stands vacated by operation of law, my lord. Should have been listed on the 22nd. Should have been disposed of by the 22nd.
So, Mr. A. Jimomi,
My lord.
as per 226(3),
My lord.
the time of 2 weeks
Yes, my lord.
shall be effective from 5.
From 5, my lord. So the date I served the copy, and 2 weeks expires on the 19th. Now, since 19th was a holiday and the court reopened on the 22nd, should have been disposed of by the 22nd.
Twenty was not a.
We were on vacation till the 21st. my lord. Yes.
21, 22.
We reopened on the 22nd.
So this application should have been disposed on
22nd.
22nd.
Yes.
Yes, ma'am. By the operation of law, I think.
Lordship, first of all, your lordship, I believe your lordship is aware also that interpretation of Article 2263 has been referred to a larger bench by Honorable Justice Serto also, your lordship.
Gotcha.
And then which is still pending disposal, lordship, in this matter, whether it is a mandatory or director list. So it has been referred, but it is still pending disposal in this matter. But however.
Do you
lordship,
remember in which case?
Lordship, I have to ascertain because I came to knowledge only last night, but I was doing my research and then I could not find any. But if I could allow 1 day, but however, your lordship,
No, but
it can be understood on 2 interpretations in this.
the counsel for the applicant has relied on 2003 1 GLT, which is by a division.
Your lordship, definitely, I have 2014 also in this, but it is understood that it can be of 2 interpretations. Whether the question of the act of omission on me as well as on the registry will come to play in this particular case because of its peculiarity, lordship. Here, lordship, I have received a copy on 5th. On 5th of July. And it was put up for motion on 9/7/2024. And by order dated 9/7/2024, this honorable court issue notice to the respondent returnable within 2 weeks, lordship. And lordship, there was vacation of 10 days starting from 12/7/2024 to 21.
12/7/2024
To 21.
21.
Yes, Your Lordship.
So it was listed on 9/7.
It was listed, so if, Lordship.
It was listed on 9/7.
9/7, Your Lordship. It was listed for motion on 9/7/2024, Lordship.
Motion, okay, 9/7/2024. Thereafter from 12 to 21.
Yes, Lordship.
Vacation.
Lordship, here, listing on 1/8/2024. Lordship, if counted from the exact date of 14 days.
Just wait,
Yes,
ma'am. Where
Lordship.
is that order 1/8/2024?
1/8/2024.
There is no order, Your Lordship.
There's no order.
Your Lordship was not holding court that day, though it was listed. The cause list was published, Your Lordship, but
Okay. 1/8/2024. Okay.
Lordship.
perhaps even the IE was not listed, Your Lordship, only the contempt petition was listed.
Lordship, on another bench. Lordship, here, I have already stated in my written objection that there is one contempt petition pending disposal. Before filing of this vacation, Your Lordship, I have filed one contempt petition against the commissioner as well as the deputy commissioner, Kohima, Your Lordship.
In this case?
Yes, Your Lordship,
Ah.
which is pending disposal. And why? Because I have already in the contempt petition, what happened was I have already informed the deputy commissioner as well as the commissioner regarding the status quo order dated 22/4/2024, which was passed by this honorable court. I have already informed. However, what happened was in spite of knowing the fact that there is a status quo order directing the parties, they have started constructing a permanent wall structure in between the disputed land, Lordship, and it has already been completed. Lordship, it has already been completed. And if, Your Lordship, if this application is allowed for vacation, even my contempt petition will become infectious, Your Lordship. My contempt, because, Your Lordship, here I am not challenging the allotment order of respondent number 6 of the applicant. I am challenging the eviction order, the restraining order, as well as the cancellation order of the petitioner's land pata, Lordship. I'm not challenging the allotment order in this. What happened after the status quo order was passed, Lordship? After 2 months, lapse of 2 months, the applicant has implemented themselves, and only after a lapse of 1 month they have filed for vacation. But in the meantime, they were aggressively constructing, knowing even the respondent number 6, they have already been implemented. But however, they know they are already aware of the status quo order that has been passed. But however, they, without adhering to this honorable court's order, they started constructing the permanent structure, retaining wall, Lordship. And it's already been completed, Your Lordship. I have already annexed all the pictures also, along with the dates that the construction has been going on, Your Lordship. Here in this, in the contempt petition, the respondents, the contemptor, are yet to file their reply, Lordship. Lordship, here, I may be allowed to give a short statement, Your Lordship, as to why the status quo order should not be vacated, modified, or cancelled, Your Lordship.
No, ma'am.
Yes, Your Lordship.
First, let me understand the facts. You are coming in between.
Yes, Your Lordship.
Just start, let me see. What is the facts? Just from the beginning, give me some gist
Your
of the
Lordship.
facts.
Here,
From your petition, let us see from your petition. Okay. Let us see the gist. from the petition? I'm still not able to digest the whole gist of the case.
Lordship,
Yes, please.
the petitioner, there are two petitioners here, Lordship.
Yeah.
And then I am challenging the eviction, the restraining, as well as the cancellation of my pata.
Petitioner, there's only one petitioner.
There are two
in the
petitions.
petition.
Yes, your lordship, analogous, two writ
Next
petitions.
writ petition also.
Oh,
There are two writ petitions, your lordship.
okay, we are on 58.
Yes, your lordship.
They should be clubbed together in fact. Your Lordship.
58, 59.
Yes.
Let us see that 59 also. Let us just. 58. Let us first see the facts. Let me first.
Lordship, here the
Yes.
petitioner.
58.
Yes,
Ma'am?
your lord, 58, your lordship.
Yes. Yeah, Kamba.
Akumba, your lordship.
Yes, yes.
Your lordship, the petitioner here is the owner of the land, having rights, title, and interest, and has constructed permanent buildings, your lordship, and have been living peacefully since 2010. Lordship, here, to my annexure A, is a residential certificate which has been provided by the chairman, stating that the petitioner have been residing in this particular area for more than 13 years, but however, it should be 15, your lordship. They have already mentioned this. Page number 21. Lordship, here, while living peacefully, lordship, on 16/6/2023.
First, ma'am, let us go to the genesis. Where is your allotment order? Let us go. Let me at least get some knowledge on the facts.
Lordship, here, it starts from 22
Page
B, page number 22. First is the sale deed. Lordship, here, why I have annexed this to is, there was allotment order, your lordship, no doubt. But later on, what happened was the landowner, the question of landowner came. So in this also, we had to pay. Though it was not mentioned in my petition, your lordship, but this is one of the classic example, your lordship is also aware in this kind of issues, that the question of landowner came to play in this case also. So here, that's why I have annexed. So this shows that I do not have any mala fide intention in this. I have already annexed my annexion B as the sale deed as well as the land pata, your lordship. Land pata starts from page number 23. Thereafter, your lordship, page number 24, a part of land was gifted to the petitioner's uncle, who is petitioner number 2. In 59, your
besides
lordship.
this land pata at page 23.
Yes, your lordship.
After this pata is issued subsequent to this sale deed.
Yes, your lordship. Page number 24, your lordship.
Okay. Then 24 is, you have gifted a portion of the land.
Yes, your lordship.
To the petitioner in 59.
Yes, your lordship.
To the petitioner.
Petitioner 59.
Thereafter,
your lordship, I have filed for pata, and then the pata, your lordship is aware that while applying for pata, lordship, there are certain procedures that has to be followed. And while applying for pata, even the LSRO, the land survey officer, also came and surveyed and gave no objection. And then we have also gone for published in the newspaper for no objection. And likewise, the pata was granted to me, lordship. Until date, I am giving my revenue every year, lordship. My revenue is up to date.
So this is the pata of the land which is retained by you
Yes, your lordship.
after you are gifted.
Yes, your lordship.
Okay, then
After this, your lordship, the petitioner were residing peacefully without any problem for any corners, your lordship, till on 16 June 2023, that is page number 30, your lordship. Annexure F. Yes, your lordship, I was given a restraining order. I was given a restraining order stating that I have been illegally encroaching construction activities. And so therefore, in para number 2, therefore you are hereby directed to refrain from undertaking any construction work within the said site immediately. Further, you are asked to submit land documents within 15 days from the receipt of this order, lordship, failing which legal action shall be initiated against me. So, your lordship, on this, within the stipulated date, your lordship, I have given my reply before the deputy commissioner, annexing all the relevant documents, your lordship. The reply is at page number 32. Annexure G. I have stated that.
what is 31?
Is the ground. There, the ground, it says encroachment and undertaking illegal construction activities within the Honorable Judges Bangalore, New Minister Seal. This was the ground, lordship. This was the ground.
This is more or less a notice
Yes, your lordship.
issued under section 5(1) of the Eviction Act.
Yes, your lordship. Notice. Lordship, here, after this, I have replied that I am not encroaching any other particular land except I have my own, and then there is no construction activities going on. That was my reply. And annexing all my papers.
Just what have you stated? You have. So you have not undertaken any construction as of
No,
yet?
your lordship, I have not. Thereafter, your lordship, while receiving this eviction order in the morning of 29/11/2023 at around 9:30 a.m., your lordship, I've already stated in my para number 8 that the petitioner was shocked to see the revenue officer 5-6 Dobashes along with some police personnel outside his premises, your lordship, aggressively directing the petitioner to immediately vacate the house. So, your lordship.
Where is the question of house when you have not undertaken any construction?
Your lordship, here, construction, I have already built the building. The building is already there since 2010, your lordship. The house is already there since 2010.
That house
There's a
is-
land and there is building
Your lordship,
standing there on also.
It appears that the land allotted is beyond the compound of age 44 also. So probably the house is outside the compound.
Lordship, that's probably your lordship, but however, as per.
Within the
order.
compound, there is no construction.
That you have made that very clear in your statement.
Yes, your lordship. I am saying
So-
this is my land.
Your land.
Yes, yes, your
As
lordship.
per
And then
the-
I'm not under the compound, or your lordship, I have already stated that this particular plot of land, is well within the pata, that has allotted, and I have bought the land also, your lordship. It's well within. I have not constructed any, nor I have encroached the land, lordship. Lordship, here, what happened was without issuing, without ignoring my reply, Your Lordship, on 29/11, I was asked to vacate the land as well as the building immediately without any cause, Your Lordship. And so on asking, what happened was the respondents.
Madam,
Yes, Your Lordship.
is it not incumbent on you to make the original landowner a party here?
Lordship,
Because
here.
actually, it is only after your purchase from the landowner that you have been allotted a pata. Well, the gray area is whether the person who has sold you the land is the landowner.
Lordship, here.
So
If
was it not
if it is
necessary
right
for
title and
you?
interest, Your Lordship, if it is
Was
right
it
title
not
and interest.
necessary for you to have also implemented that landowner?
Lordship, here, I am challenging the illegality of the orders, the cancellation order, the eviction order, and then the restraining order, Your Lordship. The illegality, the act done by the state respondents. So, Lordship, eviction order was passed. Being aggrieved, Your Lordship, I filed a writ petition. The writ petition, this honorable court disposed with a direction to approach the appellate authority, that is the commissioner. And in the meantime, 15 days status quo was issued.
No,
Yes,
just
Your Lordship.
let me understand. After this eviction was passed,
Yes, Your Lordship.
have you approached the commissioner?
After being aggrieved,
Have
since
you
the
approached
day, Your Lordship, here, I have received the eviction order, I've received
Yes,
very late.
Eviction order was, what is the date of the eviction order? Was it 19 November or 14 November?
Lordship, 17, 19, Your Lordship.
Is it?
17/11/2023, Your Lordship.
That is page 35.
35H. Eviction order 35, page number 35, Your Lordship.
And what is this 36?
Lordship?
What is this 36, page 36?
36. 36 is the ground for eviction, Lordship. Form of notice under section 1 of section 6 of Nagaland Eviction of Persons Unauthorized Occupation of Public Land Act 1971.
Okay, after this eviction notice.
Yes,
After
Lordship.
this eviction notice,
Lordship, I have filed a writ petition, been aggrieved, stating with the ground that the order of eviction to persons in unauthorized occupation of from public land. Lordship, here it clearly says that evidence should be adduced, any evidence should be adduced in support thereof, and after making such further inquiry, Lordship, that was my ground. And however, Your Lordship, this honorable court was.
what is this order? WPC 324?
Yes, Your Lordship.
What is this order?
This order.
12/2022?
Agree, Your Lordship.
23?
This order, this honorable court passed an order to approach the appellate authority, that is the commissioner.
Okay.
Yes, Your Lordship. And so likewise, we have approached the appellate authority appealing on the ground of appeal, Your Lordship, under section 12, Your Lordship, under section 12.
This page 42.
Yes, Your Lordship.
Okay.
In the meantime, Your Lordship, by the commissioner's order to 12/2/2024, Lordship, the commissioner has directed status quo to the parties. That is in annexure L, Your Lordship, to my additional affidavit. Your
Page?
Lordship. To my additional affidavit, Your Lordship.
Did the status quo order passed by the commissioner?
Yes, Your Lordship. Additional affidavit. In additional affidavit, page number 4, Your Lordship. I may be allowed to read the operative portion, Your Lordship. Therefore, the undersigned authority deems fit to stay the operation of the eviction order dated 17/11/23 passed by the Deputy Commissioner and directs all the party to maintain status quo till further orders. Lordship. Till further orders.
After this?
After this, Lordship, while the status quo order was in operation, shockingly, I have received, the petitioner have received the cancellation order of the land pata, Lordship. That is in page number 52K.
But this order is passed pursuant to the commissioner's approval.
Agree, Your Lordship. I did not receive any papers except for the cancellation. But however, the approval of the commissioner, Your Lordship, I have already mentioned in my written objection, the approval of the commissioner and this cancellation order is questionable, Lordship. And the status quo order that has been passed. Lordship, the approval was given by the additional Deputy Commissioner, Office of the Commissioner.
Where is that?
Yes.
Where
Is,
is
Your Lordship? IA, Your Lordship, 101. This instant application, Your Lordship, for vacation. This instant application. IA 101/2024, Your Lordship. This instant application for vacation, which has been, Your Lordship. Page number 16, annexure A.
Page 6.
Page number 16, annexure A, Your Lordship.
This 101, page number?
Page number 16, Your Lordship. Lordship, here, the approval for cancellation was given on 1st March 2024 by Additional Deputy Commissioner, Headquarter, Office of the Commissioner. Lordship.
Yeah, it's all right. No,
Yes.
Nothing wrong.
Yes, but however, Your Lordship, why I'm saying it contradicts. Why? Because here, that the status quo order, which is in my additional affidavit, Your Lordship, status quo order 12/2/2024. Is already in operation, which has been passed by the commissioner.
Where is that? Status quo order?
Your Lordship. Page number 4, Your Lordship.
Of?
of additional affidavit, Your Lordship, additional affidavit, to my additional affidavit, annexure L.
Then which is the order you were referring? The approval order passed by the commissioner?
Yes, Your Lordship.
Where is that? Where is that?
It's in the IA 101.
Page?
Page number 16, Your Lordship, annexure A.
16. This status quo order was passed on 12 February 2024.
Agree, Your Lordship.
And the approval order for cancellation was passed on 1st March 2024.
Yes, Your Lordship.
So what is wrong there?
Here, Your Lordship, there is a new development. There's a new development where during the pendency of this, Your Lordship.
During dependency of what?
During the pendency of this IA, I have received one summon by the commissioner. I have already annexed in my written objection also. And then I will be praying for additional affidavit, if Your Lordship allows also. Here in my written objection, Lordship. Written objection at page number 17. Here it clearly says summon 8 July 2028. It clearly
July
says 2024, my apologies. Your Lordship. I'm going way ahead. Your Lordship, it clearly says in continuation to this office stay order dated 12/2/2024, notice is hereby issued to all the concerned that the hearing of the appeal petition filed by Sri Akamba, that is the petitioner, and P. Shobham's petitioner number 2 under section 12 of eviction of person is are hereby fixed on 17/7, that is 17/7/2024 in Commissioner Conference Hall. So it clearly speaks about in continuation of the stay order, Your Lordship.
Any consequential order passed pursuant to that?
Yes, Your Lordship.
Any order passed pursuant to that?
Any order, Your Lordship, after this, an order was passed that since I have already given my reply, we have appeared before the commissioner stating that since it is pending disposal and then status quo order has already been maintained, and so an order was already given. We have received only day before yesterday, Your Lordship, in this.
Mr. Ejmomi, I think there is something wrong. After this final approval was passed, again, why the show was, why is it necessary?
Your Lordship, now the entire basis that she has a pata, that is gone. Which means.
No, it's not.
Because of this approval for cancellation?
Yes, my lord. So the principal argument of the petitioner that the land belongs to the petitioner and then the petitioner has a pata, that is gone. So therefore, we revert back to the Eviction Act. Illegal occupation of public premises. And Your Lordship will see in that page 16. Your Lordship may kindly see page 16 again of
Page
my
16 of?
Of my IA.
This approval?
Yes, my lord. If you may go to the text of the approval. So the text says, with reference to your office letter dated 21/2/2024, and on the subject cited above, I am directed to convey the approval of the authority for cancellation of pata number to 2 pata numbers. So now, Your Lordship, this is the exercise of authority under one jurisdiction, and that is exercise of authority under the land revenue regulations and rules. This is one jurisdiction, a completely different jurisdiction. And the other jurisdiction is now, Your Lordship.
This letter dated 1st March 2024.
Yes.
Will it not be under eviction of a person?
No, my lord, no. This is under the land revenue regulations. Cancellation of pata is under the land revenue regulations. It's a different jurisdiction, Your Lordship. It's a
Your
different
Lordship,
jurisdiction.
why? How? I have been cancelled. My land pata has been cancelled. I have not given any reasons to it, Your Lordship. And then moreover, Your Lordship, on going through the IA, whether to show whether the applicant is aggrieved by the status quo order, nowhere in the application is shown. that they are being aggrieved because of this present status quo order, Your Lordship.
No, Your Lordship, this is,
The
there
status
is
quo
something
order,
else here.
they are not being aggrieved, Your Lordship, at all.
Your Lordship, there is something
But
else
however,
here.
I've been in possession of the land since 2010. And then the balance of convenience, even the prima facie, Your Lordship, and then there will be irreparable loss if it is vacated, Your Lordship.
No, Your Lordship, as far as vacation is concerned, by operation of law, it must go. There are no two ways about it. My another friend is referring to a reference to a larger bench, but there is a division bench judgment which is still good law. That reference doesn't come in the way of following this direction, Your Lordship. And Your Lordship will see the last line of this of the Measure 16, cancelled in respect of such and such, which were erroneously issued within government quarter number AH 44 at New Ministers Hill, Kohima. Erroneously issued. The fact that the petitioner purchases in the year 2010, that is irrelevant, Your Lordship. That discloses a
The right
practice,
title and interest, Lordship.
which is prevalent, an illegal
Lordship.
practice which is prevalent in Kohima, Your Lordship. The petitioner cannot ask this honorable court to countenance such a practice. What is happening? The practice is very clear. Within government quarters, so-called landowners sell it to private individuals on the basis of such
Mr.
sale.
Homi, just one clarification.
My lord.
This approval for cancellation dated 1/3/2024.
Yes, my lord.
This was issued consequent to the show cause notice issued under the Eviction Act.
No, my lord, no. This is a cancellation of the pata in terms of the land revenue regulations. I'll show that, Your Lordship. I'll show that.
Your Lordship, nowhere is mentioned.
No, it doesn't have to be mentioned.
It's just they have written.
You know,
they have errored
Let us go to the show cause.
It is
Let us
just-
go to the show
Your Lordship, it
cause.
is an exercise of statutory authority.
Let us
A
go
show
to-
cause is purely under the Eviction Act, Your Lordship.
Ah.
Show cause is purely under the Eviction Act. No disputes about that, Your Lordship.
Page number 17, Your Lordship. Show cause, summon, Your Lordship.
Your Lordship will consider the issuance of pata is under the land revenue regulations. It is not under the Eviction Act. Confirmation and cancellation of pata is under the land revenue regulations. It is not under the Eviction Act, Your Lordship.
Lordship, on going through the petition also, the application, here, the applicant have been allotted only in the 11th January 2022, where it says that in pursuant to Chief Minister's Secretariat letter, this quarter has been temporarily allotted, Lordship. It's a temporary allotment, but however, Lordship, here, after entering, Lordship, here, what happened was, after even I have already mentioned in my contempt petition, Your Lordship, after entering, even the applicant is well aware of the status quo order, but however, Lordship, however, the Deputy Commissioner did not listen.
In fact, if your
Maybe
Lordship
there
will
was a
come to
contract.
paragraph 15 of my application, I have stated very clearly, paragraph 15 of my application. At page 11, that the cancellation of the patas is well within the powers authority of the state under the Assam Land Revenue Regulations. It should be 1886, so it's a wrong date, my lord, and the rules framed thereafter. Therefore, the cancellation of the pata issued to the opposite party number 1 writ petition has rendered the instant petition infructuous. In fact, Your Lordship, the approval is a statutory exercise of power under the land revenue regulations. That approval has not been challenged in the writ petition. It is a separate exercise of statutory authority.
This,
altogether,
Your
Lordship.
Lordship,
Page 16
the
has not
approval,
been
Your
challenged.
Lordship, moreover,
It has not been challenged.
Your Lordship, if I may, the approval letter, how can I challenge when a copy has not been served to me, Your Lordship? When a copy is not given to me, where will I get the approval, Your Lordship?
Actually, I have served this copy on the 5th of July. My lord.
Lordship, here, the approval. In the main petition, I have been asked why it has become infructuous because I have not annexed the approval letter. But however, Your Lordship, Annexure 16, page number 16, Annexure A, it clearly, I have not given a copy. Then where I will get and where I'm going to challenge in this, Lordship. Only after filing this IA, it has come to my knowledge that there is one approval. And then again, there is one complaint also that has been filed by the applicant.
And insofar as the status quo order is concerned, Your Lordship, under the Eviction Act, Your Lordship, insofar as the status quo order is concerned, the petitioner is still in the building. He has not been evicted. The building which he claims to have built on the land allotted to him, where he is residing, both petitioners, they have not been evicted from there, as far as I know. In the
Lordship,
instructions that
at
I've-
least there, I have a little immunity from this honorable court, Lordship, at the moment, because of the status quo order. At the moment. Lordship.
So this applicant, Your Lordship, is only concerned with the plot of land within the compound of Government Quarter AH 44, which has been allotted for the judge's accommodation. I'm only concerned with that. The remaining portion, the petitioner and the state respondents, they will have to tackle that.
Lordship, here, encroachment of Judges Bangalore AH 44, Lordship. There is no description of the land here also. There's no description. Nothing is just mentioned.
It is a
It's
quarter,
just
Your
they have
Lordship, and it
stated
is
that
an
they have been
enclosed,
temporarily
enclosed
allotted.
compound.
And then the complaint was filed in the year 2023, Your Lordship.
What was the order passed by this court? Because of which the contempt petition was filed?
Your Lordship. Order dated 22/4/2024, Your Lordship.
Of
my application.
Application. Your Lordship.
Page 19 and 20 of my application. Status quo order.
Here, Your Lordship, I may be allowed to read here also. Para number 2, the learned government advocate pray for some time to take instruction. Prayer is allowed. Here, Your Lordship, I have also heard the learned counsel of both parties in the matter of prayer for interim. So, Your Lordship, in the meantime, all the parties were heard in this. All the parties were heard. Both sides are directed to maintain status quo as on today in respect of the disputed land.
I was not heard.
Yes, Your Lordship. Yes, Your Lordship. Here, I am not challenging the allotment order of the Bangalore, Your Lordship. I'm challenging the eviction, the cancellation, and the restraining order that was illegally passed by the Deputy Commissioner. I'm not aggrieved by the allotment order, Your Lordship.
So why the contempt? Because of this order? Why the contempt?
Lordship, after the status quo order was passed, Your Lordship, and after intimating to the Deputy Commissioner regarding the status quo order, they started to construct retaining wall between the disputed land, Lordship. Between the disputed land. And so I have filed my contempt. Only after the status quo order was passed, the state respondents, they are aware of it, Your Lordship. They are aware of it because even a copy was given to them and they have duly received. They have duly received. Knowingly, they have started constructing that permanent retaining wall. Cemented, Your Lordship, cemented retaining wall. And it's already completed, Your Lordship. It's already demarcated, Your Lordship, here.
So you are presently residing
I'm-
out of that boundary wall?
Your Lordship, the disputed land is like this, and in between, the petition number 2 is here, petition number 1 is here, and then they have constructed the cemented retaining wall in between, and then below is the Honorable Judges Bangalore. Below, is far below, Your Lordship.
So where are you residing now?
I'm
Outside
residing
outside the boundary or inside the boundary?
I'm residing there, inside the boundary, inside where the applicant claimed to be, Your Lordship.
No, you
I'm not
are
inside-
residing within the boundary erected by the government?
No, Your Lordship, no.
Outside?
Outside, Your Lordship. I am outside, and then my house is outside.
Huh.
My house is also outside, Your Lordship. And then they have constructed within my land, stating that this is the boundary. They've already demarcated, Your Lordship. And then that's why a contempt is attracted, Your Lordship, in this. When a status quo order has been passed, how can they just come aggressively and then construct? in a very high-handed manner, Your Lordship.
This case is getting more murkier.
I agree, Your Lordship. There's a peculiarity in this case.
Let us see that, summon which was issued to you after this approval for cancellation. There was a summon which was issued to you.
Agree, Your Lordship.
Let us see that. Where is that summon?
Your Lordship, 17.
Of?
Next, to my written objection. This present IA, Your Lordship. Page number 17, Annex 2.
Written objection. Page?
Page number 17, 17. Yes, Your Lordship. Summon, 8 July 2024. In continuation to this office stay order dated 12/2/2024, notice is hereby issued to all the concerned that a hearing on the appeal petition filed by Sri Akamba and Sri Pishokum under Section 12 of Nagaland eviction of person in authorized occupation of public land is hereby fixed on 17/7/2024, Wednesday at 11 a.m. in Commissioners Conference Hall. The undermentioned official parties are therefore directed to attend the hearing positively in person or through their representative, Lordship. So on the fixed day, we have the petitioner as well as the representative, they have appeared. And then we have given one reply stating that a case is pending disposal, Lordship.
Reply is in?
Reply to the commissioner, Lordship.
Is in page?
Page number 18. My apologies, Lordship. Page number 18, Annexure 3. In this reply, Your Lordship, we, the petitioner, have intimated the updates of the present case, Your Lordship, before the commissioner, and that, and moreover, Your Lordship, only day before yesterday, we have received an order, Your Lordship, an order of the commissioner stating that.
Yes, any order passed by the commissioner on the summon?
On this, but on 31 July, Your Lordship, on 31, that is day before yesterday, Your Lordship, 31 July, we have received one order of this reply, Lordship. Oh, it's not clear.
Mr. Ejmomi, do you have a copy of this?
No, Your Lordship. In this, I will be filing one additional affidavit on this, Your Lordship.
Yes, you file an affidavit, Mr. Jimomi. I think this will be necessary.
Your Lordship, as far as 226(3) is concerned, Your Lordship, it is by operation of law. It requires
Let
no
us,
argument.
let us decide all the petitions together. I think, let us not decide the case in piecemeal. I think there's something more deeper in this case, which we all have to see that justice is dispensed.
Of course.
226(3), you're right, correct. But I think besides that, I think that will not actually close the case.
That is true, my lord. But if I may humbly submit, my lord, as far as 226(3) is concerned, there is no room for any discretion. There is no room for any discretion.
We will actually take that into consideration while disposing the case finally.
Your Lordship, as far as I am concerned, I have a responsibility to place the case of the respondent number 6 before the Honorable Court. And my humble prayer is that 226(3) must be given effect to. And there is no discretion as far as 226(3) is concerned.
No, there is also a stay order pending in connection with that. No, not stay order, contempt.
Well, no, that's a different issue.
That's
a different issue, my lord. A contempt petition pending is again a different issue.
If we vacate the stay,
My lord.
what consequences will follow?
Your Lordship, consequences, the main writ petition will still be argued, my lord. Main writ petition will still be argued insofar as the eviction process is
No,
concerned.
but if the stay order is vacated, then it will give the discretion to the government to take recourse to something which.
No, my lord. The Commissioner's status quo order in the Eviction Act is still there. That is the alternative remedy which is still pending, my lord. Your Lordship will kindly consider that. Your Lordship will kindly consider that. The alternative remedy is also pending. The alternative remedy is actively being pursued. There is an interim order as far as the alternative remedy is concerned. In fact, the petitioner is pursuing the alternative remedy. The challenge to the process under the land revenue regulations, that should be a different process altogether, Your Lordship. It cannot be clubbed together with the act, with the process under the Eviction Act as of now.
Well, ultimately, we will hear, but ultimately this has to go to the civil court. Because
Yes,
this court
ultimately,
will not be in a
ultimately,
position to
that may
decide
be, that may be the
right
proper
element.
course, ultimately, my lord. Ultimately, that may be the proper course.
But in between all this nitty-gritty, contempt and all this, I
Yes,
think.
ma'am. So, but my lord will appreciate the alternative. It's not as if an alternative remedy is there and it's not being pursued. It is being pursued. It is being pursued, and there is a status quo order there in that case. So, where is the necessity for this honorable court to be actually hearing this matter now, my lord? Let the process under the Evictions Act, under the Eviction Act, be closed. Then the petitioner can come before this honorable court again.
Lordship,
If any order is passed.
if I may.
Madam,
Yes,
Madam,
Your Lordship, if I may.
in
one-
view of this order 31, July 2024,
Yes, Your Lordship.
even if the stay order is vacated, I think this will not do harm because you are protected by this order.
Yes.
In a way, agreed, Your Lordship. But however, Lordship, going into the merit of the case and then on going through the application for vacation, Lordship is also aware that major three components has to be attracted. And the Lordship here, why they are aggrieved, I do not understand. In the IA, I do not understand why, in what way the status quo order have been aggrieved by that, by the applicant. Because, Your Lordship, here, they have in the IA for vacation, they have just mentioned the facts of the case, Lordship. And then in no way they have mentioned that because of this particular status quo order that we have been aggrieved. Nowhere is mentioned, Your Lordship. There is no prima facie in this, Your Lordship. There is no irreparable loss. They have not shown in any way that there is no irreparable loss. And then there is no balance of convenience, Your Lordship, in this. In no way in the IA for vacation is mentioned.
Okay.
So in what way
Madam,
they are aggrieved, Your Lordship?
You file an affidavit, additional affidavit on this order, give a copy to the learned
Agree,
counsel
Your
for the
Your Lordship,
planning council. And
agree.
then thereafter
One-
we will again see.
summoned.
But maybe I am inclined to go by this 226(3). So far as the status quo is concerned.
Your Lordship,
I'm making my mind clear.
but keeping in
Because
mind, Your
actually, even if the status quo order is removed, assuming that status quo order is removed, you still have the protection of this order. 31 July 2024.
Yes, agree in a way, but the cancellation order, I'm not been protected, Your Lordship.
No, cancellation has not been
Cancellation order is
stayed,
not
just
been
status
protected.
quo. Cancellation order has not been stayed, it is just a status quo order, my lord.
Your Lordship,
This
cancellation.
this order 31st July 2024. See, the instant matter is kept in abeyance till disposal.
Agree, Your Lordship.
Yes.
But however, as
So
per,
till the High Court, till this court disposes all this writ petition.
then Your Lordship, if I may,
Yes.
if I may, a small prayer, Your Lordship is also aware that I have already brought to the notice that interpretation of 226, Your Lordship, 3 is, it has been referred to a larger bench, Lordship. And then if, Your Lordship, this IA attracts, Your Lordship, if Your Lordship is of the opinion that this attracts Article 2263. So whether this matter can be kept in abeyance till disposal of the matter of that Lordship. If
No, we
Yes.
now have a binding precedent. We have a binding precedent. So just because the matter is actually that the higher bench is a bigger bench is of the matter.
Lordship,
When,
I cannot overrun a division bench, but however, I have a citation of a single bench also, Your Lordship, of a single bench, Lordship, where it has been clearly interpreted regarding the 2263, Lordship, where they did not, where most of the single benches, they did not went into the explanation in depth regarding the counting of days, Your Lordship. But however, I have a single bench which has. been
No,
filed
here
by-
I think the dates
Agree,
are very
I
clear.
cannot go above, but however.
Here the dates are very clear. Correct?
Agree, but however, on that particular case also, Your Lordship, no doubt the case where the dates were mentioned, but they put up the case for more than 1 month, Your Lordship, and then the IA for vacation was dismissed on that line. And then some division cases were also cited on that particular case where it was in the favor of the applicant. Where it was in the favor of the applicant, Your Lordship. But however, on going through.
Okay, we
Yes, Your
give you the opportunity to produce all those things. Let us.
Yes, Your Lordship.
Your Lordship, if I may, Your Lordship, again.
No,
As far
again.
as the division bench judgment is concerned, Your Lordship, that is still holding the field.
Yeah, this is by Madras High Court.
Yes, Your Lordship.
Our division bench
This
case
is,
is
Your
still holding the
Lordship,
field.
even Gauhati High Court bench, one judgment has been also referred here. And then even one division bench has also been referred, which is for the applicant. which
You
is for
produce
the-
all those. Let us.
I agree, Your Lordship. I have only one, Your Lordship.
Okay, we give you another chance. You file an affidavit on this order also and produce all the relevant case laws which is in your favor.
I'll do that, Your Lordship.
I think within a week's time we will hear it.
Coming Monday, my lord?
Monday or Tuesday.
Monday, coming Monday. my lord.
Okay. Okay. Heard MS. Heard Mr. A. Jimoni, the learned standing counsel, Gauhati High Court, Kohima bench for the applicant. Assisted by MS so-and-so. MS Santila, the learned counsel for the petitioner opposite party. And Mr. Imtimso, the learned additional advocate general for the state. In the course of hearing, Mr. Naxantila, the learned counsel for the petitioner opposite party, has placed a copy of the order dated 31st/7/2024, passed by the Commissioner, Nagaland Kohima. Stop. This court desires that the order dated 31/7/2024 be placed in the form of an affidavit for giving equal opportunity to go through the same to all the parties. On the next date fixed, Mr. Naxantila, the learned counsel for the petitioner opposite party, shall also come with relevant citations on Article 226(3) of the Constitution of India.
Your Lordship,
Listed.
if I may, my lord,
Yes.
just to safeguard my position. My prayer is that insofar as 226(3) is concerned, as on date, the order stands vacated and there is no need to grant any more time to the petitioner.
Okay, Mr. A. Jimobi, the learned government advocate, however, submits that as on date, Article 226(3) of the Constitution of India is in operation, and therefore granting time to the learned counsel for the petitioner opposite party may not serve any effective purpose. This is the case again on 12. 13, let's make it 13. Tuesday.
Monday, my lord?
Tuesday.
Tuesday. Very good.
Listed again on 13, 13/8/2024.
As part heard, my lord?
In the admission hearing column. As part heard.
Much obliged.
Much obliged.
Yes, same order for item. This is same order for item
Yes, Your
23.
Lordship, yes, Your Lordship.
Okay. Same order for item 23.
We should be clubbed together, my lord. Yes,
Yes, yes, yes. It is with 22, 23. Yes, they're clubbed together. Correct, KV, clubbed together.
For orders. Item number 24 and 25.
May I please, Lordship?
Yes.
Lordship, service upon the newly included respondents are still awaited.
Who are the newly included respondents, ma'am? This is, where is your amended writ petition? Okay. Who are the newly included respondents?
Lordship, in WBC 98, 7 to 13. And in the
7, just wait. 7 to 13.
and in WBC 99, 13 to 18.
WPC
99.
98, it is
7 to 13.
7 to 13. And
WBC 99, 13 to 18.
WPC 99, 13 to
18.
18. Service upon the newly implemented respondent 7 to 13. Still awaited, listed after 3 weeks. Then again, that is WPC 98, okay? In 99, service upon respondent number, the newly implemented respondent number 13 to 18, still awaited, listed after 3 weeks.
Item number 26 and 27.
Yes.
May I please, Your Lordship?
Yes.
My senior, he's indisposed, so this matter may be adjourned for 2 weeks.
Two weeks.
Yes, Your Worship. Or a week. Maybe it can be listed next week.
Worship is a review matters.
Huh.
These are review matters.
Yes.
So you concern the bench, concern bench.
It is between the petitioner and this
Yes.
court. Only thing is that you have not filed your affidavit in the main writ petition.
No, not yet. So in item 27, Your Lordship, I may allow a 3 weeks time to file affidavit. And item 26, this matter has to be heard when the appropriate bench is available.
In this review petition, okay. MS so learned counsel for the petitioner submits that Mr. Siti Jamil, the learned senior counsel, is indisposed. And therefore seeks adjournment of the case after 2 weeks.
Yes, Your Worship.
Prayer is allowed, listed up to 2 weeks. Okay. In this WPC 254, okay. WPC 254. Mr. Im Kim Sung, the learned additional advocate general, is allowed 2 weeks time to file affidavit in opposition on behalf of the state respondents. Okay.
Bless Your Worship.
For hearing item number 39.
Yes, what is the matter?
My lord, before starting with my argument, my lord, I may be allowed to point out something, my lord.
Yes.
My lord, this writ petition, the petitioner has filed this writ petition challenging the appointment of the private respondent.
You are the petitioner.
I'm the petitioner.
Okay.
On the ground that my case has not been considered on land ownership and that the respondent number 4 has been appointed without any due process of law. My lord, when the government filed their affidavit, the government has made a claim that the land has already been questioned and requisitioned by the government. But my lord, in the last page of the affidavit, that is page 14 of the government's affidavit, we have annexed a document by which the land compensation has been fixed at rupees 900 per acre. My lord, the rate has been fixed. Rate has been fixed. But there is no actual payment receipt or no payment receipt at all. So with my limited knowledge, I feel that if we go on with the hearing also, the hearing will not be conclusive because there is no payment receipt with respect to the land. So
that means you have not been paid any land compensation.
My lord, that is my stand. My claim is that I have never been paid with the land compensation, but the government has annexed a document of 1982, 8 March 1982, by which the land compensation has been fixed at rupees 900 per acre.
But the government does not say that the land compensation has been dispersed.
They are saying that it's already been paid. The government affidavit, in their affidavit, they are saying that
who is
it
for
has
the
already
government?
been compensated.
Your Lordship.
Produce the records if you have paid. If there's no record, how do you say that you are paying?
Your Lordship, initially when the land was acquisition, the notice was issued by the Deputy Commissioner stating that the land was obtained from 2 landowners. And the petitioner is nowhere on record, Your Lordship, stating that he's a landowner. Moreover, the landowners, they have stated that they have agreed to give the land on payment of land compensation. So the notice was issued like that, Your Lordship, and later on, the last paragraph of the notice, it clearly states that if there were any claims and objection from any side, be the individuals or landowners, then they should submit their objection within 30 days. But within this period, no objection was received, Your Lordship. That's why the office was established. And coming back to the petitioner being the landowner, there is no records which shows that he's the landowner, because in the deceased notice also it's clearly said that only 2 individuals are the landowners. That is,
my lord,
now the question arises whether you are a
my lord,
landowner.
I'll come to that. I'll come to that. My lord, my grandfather was Chumdamo Ovung. Asau Ovung, which the petitioner is, the state is claiming is Chumdamo Ovung's brother. Chumdamo Ovung's brother. And
the landowner.
Yes.
Landowner is
Yes.
Chumdamo
My
Ovung's
grandfather's brother. So all the same, because landowner was land was donated by my grandfather's brother. So that was their inherited property. So that is how I have also acquired the right. And that is how the landowners, the relatives of all the landowners have issued a no objection certificate for me to claim the grade 4 post. So my only question is whether the land compensation has really been paid or not. Because the government affidavit does not disclose anything whether it has
Okay.
really been paid or not.
If your affidavit does not disclose anything, whether you have paid anything or not, a certain income.
So if we are to go on with this-
MSIME, a certain income.
Yes, Your Lordship.
Because like any government transaction payment of compensation on all this, there must be some record. Because government will not just blindly just issue the cash without any receipt.
Yes, Your Lordship.
So just try to ascertain.
Yes, Your Lordship.
MSAIME shall on the next date fix produce the records, if any, substantiating that land compensation was paid to the landowners. Okay? You come?
Yes, Your Lordship.
Only on the specific. Listed again after?
1 week, my lord.
1 week?
Yes, Your Lordship.
Listed again after a week.
Bless my lord.
Yes, next.
Hah? Gila. Alat.
Okay, thank you.